There we go. Welcome to Senate Select Committee on Veterans Affairs. We're waiting for, obviously at noontime meetings, waiting for other committee members to filter in. I want to be able to hear 3 bills today, possibly. We'll just kind of see how it goes. We are confined to an hour because of other committee commitments right afterwards. So I appreciate everybody showing up. We are going to start, I'm going to pivot just a little bit because we have the bigger bill up first, but I want more of the committee members to be able to hear the testimony so we have a good chance to consider all the aspects of that particular bill. So we're going to pivot first to House Bill 2626, and I'll have Carly give us an overview of that bill. Carly?
Thank you, Mr. Chair. Good afternoon, committee. House Bill 2626, as amended by House Committee, amends KSA 73-201 to expand the veterans' preference in government employment to include current members of the National Guard and such members' eligible spouses. Subsection A provides that veteran preference in government employment shall not apply to any current member of the Kansas Army or Air National Guard or a current member of the unit of the Reserve Forces of the United States military. Subsection A4 and A5 provide definitions for an eligible spouse and service member that are used throughout the bill. Subsection C includes service members and eligible spouses for preference in initial employment and first promotion in the state government of Kansas, if competent to perform such services. Subsection E3 requires that a service member who qualifies for veterans preference shall provide to the hiring authority proof of residency in Kansas, a certificate signed by the unit commander that such service member is in good standing in their respective unit and is stationed in Kansas. Subsection E4 requires that an eligible spouse who qualifies for veterans preference shall provide the hiring authority with proof of marriage to an eligible service member and proof of residency in Kansas. House Bill 2626, as amended by the House Committee, passed the House 118-4 and would become effective upon publication in the statute book.
Thank you, Carly. Committee, any questions on this bill? Seeing none, we will move on to testimony. Thank you very much, Carly. We have first up Lieutenant Colonel Keith Marshall from the Adjutant General's Department. Also, committee lunch is being procured there was some miscommunication. Somebody forgot. Anyhow, we're trying to get some lunch in here for everybody. Colonel, thank you very much for being here.
All right, thank you, Mr. Chairman. Good morning, Mr. Chairman, members of the committee, Lieutenant Colonel, or good afternoon. Lieutenant Colonel Keith Marshall, representing the Adjutant General's Department. Thank you for the opportunity to testify in favor of this bill. We brought this bill because the law that's in place right now doesn't reflect the reality of the nature of service for our guardsmen and reservists in the state. So we have many members that don't necessarily qualify under the state law as veterans yet because they have not been activated to federal service, they have not deployed yet, and we want those people employed as close to their guard units as possible for the retention that brings. These are the people who are available to respond to emergencies here in Kansas, tornadoes, wildfires, floods, cyber incidents, whatever happens. They protect our communities, they protect our state, but they're not included in veteran hiring preference under current state law. So this bill essentially closes that gap and allows them to receive that employment preference. Civilian job stability is one of the strongest predictors of retention. Research consistently shows that supportive employers and predictable schedules increase reenlistment, and that's what we're aiming for. We want to keep the people that we've recruited and we've trained up and keep them in the state. And as commanders, we've seen the pattern. Long-distance commuters are the ones that separate first. So those with locally employed members have a lot lower attrition. So we want our Guard members employed closer to their Guard units and in their communities. And then the second piece of this is the spouse preference. So we want to expand that so spouses of military personnel receive a hiring preference. Spouse employment remains a top challenge for military families as they move around the country. We've made a lot of progress in Kansas in recent years with our licensing compacts, our fee waivers, and credentialing bills, but employment still remains a barrier. And this is one step further in the right direction for this, and it aligns with the broader family initiatives that we've been going after for the past several years. It would really send a clear message to pass this bill that we value not just the service member in Kansas, but we value the entire family that makes that service possible. In closing, Mr. Chairman, this is a bill that would strengthen the workforce, it would support military families, it improves Guard and Reserve retention, all while honoring those who serve and protect our state, and we urge the committee to pass it favorably. And Mr. Chairman, I will stand for questions at the appropriate time.
We have one other proponent testimony, and then we'll open up for questions. Thank you, Colonel. Next up, we have Michelle Rickert, and she's online, I believe, from Department of War in Washington, D.C. Welcome, Michelle.
Thank you, Mr. Chairman, honorable members of the committee. My name is Michelle Richard, and I am the Midwest Regional Liaison for the Department of War's Defense State Liaison Office. Our office manages state government relations for the department on issues impacting personnel and readiness. The department appreciates the opportunity to testify in support of House Bill 2626, expanding hiring preference in public employment to include current service members and eligible spouses. Our service members are crucial to protecting the interests of the United States and ensuring our national security. By implementing these changes, Kansas can ensure service members are ready to support the military mission because the state is supporting their families. This creates an environment that enhances recruiting, readiness, and retention of our entire force. I will echo many of the comments and sentiments of the previous conferee. As mentioned, this bill does two important things. First, it closes a critical gap for Guard and Reserve by making both practical and meaningful updates to Kansas law by extending public sector hiring preference to current members of the National Guard and Reserve. Second, this bill strengthens military families and improves military spouse employment by extending the hiring preference to those eligible spouses. Military spouses are a highly skilled and educated demographic, with 49% of active duty spouses and 37% of Guard and Reserve spouses holding a bachelor's degree or higher, yet they face an unemployment rate of approximately 21%, significantly higher than their civilian counterparts. Due to the demands of military service, most military families relocate every 2 to 3 years. This bill, House Bill 2626, creates stronger pathways to public employment and helps address this unique and critical challenge. In fact, on our end, the department recently launched an entirely new directorate dedicated to reducing military spouse unemployment significantly in the next year. Policies like the one in front of us today will help that goal. House Bill 2626 is a proactive step that strengthens Kansas public workforce, supports military families and service members, and improves both retention and readiness. It is an investment in the state's workforce and a powerful recognition of the sacrifices made by our military community. Thank the committee for its consideration, and I respectfully urge you to advance this bill as favorable for passage, and I will stand by for any questions that you may have. Thank you.
Thank you, Michelle. Committee, we have no neutral or no opponent testimony available on this bill, so we'll open it up now to any of our proponent conferees. Senator Klemp and then Senator Clifford.
Thank you, Mr. Chair. My question is going to go to Lieutenant Colonel. Thank you. So 2626 is a good bill. I was curious if you could just walk me through a scenario where how a spouse might utilize this change.
Mr. Chairman, thank you, Senator, for the question. Lieutenant Colonel Keith Marshall with the Adjutant General's Department. So essentially, the spouse would have some type of proof of residency in the state to show that they reside here and that their spouse is a member of either the active military or the National Guard and Reserve. They present that to the hiring authority, which would be a municipality or state government, and they're verified through those documents, and then they receive some type of permissible hiring or some type of hiring credit based on that, on like a point system, basically.
Yeah, so it gives them an opportunity to be looked at first for the opportunity. Is that kind of how you see it?
Senator, yes.
Yeah, that's very good. Thank you.
Senator Clifford.
Thank you, Mr. Chairman. Just you can stay up there, Lieutenant Colonel. A lot of the tax pieces we see would include a unmarried surviving spouse. Was there any active reason for eliminating that here? I certainly won't bring an amendment to that effect, but I'm just curious. Thank you.
Mr. Chairman, Senator, that's a great question. It's not something that we thought about or discussed. It was not purposefully omitted. We just didn't discuss that when drafting the bill. Thank you for the idea, though.
Thank you. I'm actually a military spouse, so I get not of those categories. Thank you.
Senator Dietrich.
Thank you, Mr. Chair. And this goes back to you and kind of piggybacks off what Senator Klump asked. So, and having had 1,000 employees in my school district, I saw a lot of eligibility kinds of things come through. So for the spouse, though, we usually had some sort of a signed, I mean, the House eliminated the signed certificate of the unit commander, but that's usually what we had. I mean, for everybody, you have some official document that says, yes, I'm the spouse of. So do you have any thoughts on, were you there when they removed that, and do you know why?
I was, Senator, Mr. Chairman, sorry. Senator, that's a great question. The House thought that that would create an extra barrier to employment for the spouses, and that they would have to go to the commander and then wait for the commander to sign a form. You know, military commanders are very busy, so they may or may not be available for it, and that would ultimately hinder their ability to apply for the job. So essentially, instead of a signed commander's form, that just any proof that the service member is serving, so whether it's orders or some other verification, military identification, it broadened it, basically. So it leaves that up to the hiring authority to determine.
May I continue? That's great, but that doesn't say that here. It just says residency in Kansas, proof of marriage.
To an eligible service member.
Right, but how would, and you're saying we should know that they should be bringing us orders?
Essentially, it does place it in the hands of the hiring authority, unless another conferee or the revisor would read something else in that language.
I may need to amend that. Because,
Okay.
again, you need to know what that document is. Not all of our employers would. It doesn't necessarily have to be the unit commander's signature, but there has to be something, maybe the orders, something easy. Would orders be easy, relatively easy?
Orders may work for some, but may not work for others, because our National Guard members don't always have orders either. So hence that was what was in the original bill, was a commander's verification form would be one form that everybody would be able to get, as opposed to the litany of documents that could prove service otherwise that the hiring authority may or may not be familiar with. But it was the House Committee's determination that they wanted to broaden that. So
I'd take any document, something related to.
And I don't intend to work this today. We are going to have a meeting next Thursday also, and hopefully the lunch will come a little faster. And we do have lunch on the way, by the way, and we're working on that. Yeah, if you'd like to work up an amendment and maybe work with the Colonel on the documentation that you would.
Or just wording about documentation.
That would
It doesn't have
be-
to be a specific document.
Right. Some
wanna
kind
make
of
it harder.
verifiable documentation. No, that's fine. That's fine. Any other questions? Oh, Senator Fasquedo.
Thank you, Mr. Chairman. My question is too for Lieutenant Colonel Keith Marshall. I certainly speak in support of this legislation, but I wonder, is there a certain amount of time that military individual and their spouse would reside in the state of Kansas to get that extenuating benefit? Thank you.
Mr. Chair, Senator, no, thank you for the question. The goal is to get them to work as quickly as we can once they move here. So similar to our law that we brought for schools last year, where PCS, permanent change of station orders, are sufficient to enroll their kids in school, we want to speed that process up as much as possible. So as soon as they have residency, then they can apply for this.
Any other questions? Seeing none, thank you, Colonel.
Mr. Chairman.
Committee will close the hearing then on House Bill 2626. Again, any amendments, we will plan on working those next Thursday. I'm going to move back then on the agenda to House Bill 2214, and this will be a little bit more extensive testimony, and I'll have Carly give us a bill overview on 2214.
Thank you, Mr. Chair. Committee, House Bill 2214 would enact the Safeguarding American Veteran Empowerment Act to limit compensation for assisting in veterans benefits matters. Subsection A provides definitions for terms used throughout the bill. Subsection B1 states that no person shall receive compensation for referring any veteran to another person for advice or assistance with such veteran's benefit matter or services rendered for a claim filed within the 1-year presumptive period of active duty release. The subsection further provides for an exception should the veteran choose to sign a waiver that they are choosing to deny the free services available to that veteran. Subsection B2 requires that a person seeking compensation for assisting with a veteran's benefit matter shall memorialize specific terms of the service that specifies the amount to be paid and to be signed by both parties. Subsection B4 states that no person shall guarantee a successful outcome or that any person is certain to receive specific veterans' benefits. Subsection B5 requires a specific disclosure, which is written in the language of the bill at the outset of the business relationship. Subsection B6 prohibits the use of call centers or data centers to process a veteran's personal information and the use of a veteran's personal login, username, or password. Subsection B6 also requires that any person with access to veterans' medical or financial information shall go through a criminal history record check prior to having access to such information. Subsection C provides for penalties that would be incurred should the act be violated. And subsection D provides that nothing in the bill would preclude claims or causes of action available to individuals under Kansas law. House Bill 2214, as amended by House Committee, passed the House 81-43 and would take effect after its publication in the statute book.
Thank you, Carly. Committee, any questions? Seeing none, I think we'll move on to the testimony then. Up first, proponent in-person testimony, we have Representative Rick James. Rick, welcome to Senate Select Committee on Veterans Affairs.
Thank you, Mr. Chairman and Senators. I'm here today to tell my story as a U.S. Marine that served for over 30 years on active duty and now serves as the chair for the House Veterans Military Committee, that I rise in support of this bill 2214. It's a common sense pro-veteran measure that did pass the House 81-43 for a vote. At its core, the legislation is about protecting Kansas veterans and exploitation while preserving their freedom to choose assistance that best serves their needs. Over the years, there have been a few bad actors that have targeted veterans navigating the complex benefit system. That's the issue. A few bad actors, like many have in many professions. However, there are a lot of good, honest companies that are protecting veterans. My research showed that 100 to 200 of these companies exist today, and they've assisted over 640,000 people, former veterans. First, the first thing it does three powerful things. The first thing it does, it prohibits charging veterans for claims filed within the first year of their active duty service. That helps protect newly discharged service members from vulnerable times in their lives. That's the federal law, and it nullifies the rhetoric that you'll hear that it's illegal and unconstitutional. It's simply not, and time has proven that, as these companies have been operating for decades now. Second, it requires a written agreement, full transparency, and performance-based compensation, no upfront fees, no non-refundable retainers, and no charge if there's no benefits increase. The bill allows a one-time charge only, which we passed in an amendment. That ensures fairness while allowing legitimate professionals to operate responsibly. You're going to hear testimony from the opponents that all companies are bad and extracting millions away from veterans, and that's simply not true. A large majority of these companies hire veterans to assist the veterans on their claims. Some are even former VSOs. I will say that two different companies that I hired to assist me in my claims in 2021 and 2022, far before I was a representative, they were very professional. They were companies that were financially motivated, yes. We met with Zoom meetings. They called me, they emailed me, texted me, and they kept me going to get through this long process, because it is a long process to get through the VA system. They are not accredited companies, however, unlike VSOs who file the veterans on the behalf of the veterans directly into the VA system. These groups help gather, organize, and do all the requirements for you to submit a claim. And the individual veteran is responsible for uploading them in the system themselves. And they give great step-by-step instructions on how to do this. My claims were never kicked back. They never stalled in the VA. And they were completed from start to finish in less than 90 days. One was even faster than that. I've seen them drag out for years sometimes, and months and years when they've been filed with misinformation, poor guidance, and follow-up. I recently fired a free veterans group that I hired to fill out a claim because I felt that they were lackadaisical and provided poor guidance. And I'm still working with the VA now to get that all straightened out. I guess that we compare the services for my services as if someone was in trouble with the law and they qualified for a public defender, but someone offered to hire them an attorney to defend them. Would you hire the public defender or would you hire the professional attorney? Third, it strengthens consumer protections and requires clear disclosures that businesses are not affiliated with the VA or state veterans agencies, and it prohibits guaranteeing outcomes. I tell you this because last year's chair, Representative Mike Thompson, who many of you, if not all of you know, held hearings on 2 House bills. House Bill 2213 was put forth by the VFW to ban all for-profit companies. And 2214, which you have before you today as amended in the committee, put up guardrails for these companies. These bills were never worked, so I selected the one that I thought made the most sense. With this bill, placing guardrails, we can further protect our veterans and still allow them a choice, and that's what we're asking. People have confidence in these companies, and these companies have asked for us to do this rather than just placing an entire ban on them. And with that, I ask for your consideration in passing this bill. Mr. Chairman, I stand for questions when you're ready.
Thank you, Mr. Representative. We will hold for questions until we get all our proponents, and we'll open it up.
Thank you.
Next up, we have Lieutenant Colonel Bill Taylor from the Veterans Guardian VA claim.
second thing I'm looking for is secondary conditions. You're rated for your back. I now have nerve damage in my leg. You can claim that as a secondary through the primary. I can't help with those for a fee either as an accredited agent. The only thing that I could help with would be something that you've been denied for or that we feel you're underrated for. 90% of what we do is in the first two pillars. So we chose to operate as an unaccredited entity because it better allowed me to fully serve all of the options that my veterans were eligible for. And I pay a price for that. I am not their agent. I don't have power of attorney. I'm not submitting the claim on their behalf. I'm not prosecuting it on their behalf. I don't have access to the Veterans Benefit Management System. I cannot interact with the VA. So agency means something. It's not just a term that we can blindly say applies to anyone that's helping veterans. Now, I have been actively working for the last 6 years at the federal level to change the current accreditation rules. There is currently a bill that is passed out of the House Veteran Affairs Committee called the Choice Act that provides a pathway for us to become accredited, but more importantly, puts all of the guardrails in place that we're recommending here in the state of Kansas. So once again, thank you for your time. We are strongly in support of this bill. We believe that veterans need protection, but they should also have choice. Thank you.
Thank you, Colonel. Up next, we have Ray Colas, Veterans Benefit Guide.
Chairman, members of the committee, my name is Ray Colas, and I'm here today to represent Veteran Benefits Guide in support of House Bill 2214. Hello? Yep. Now, the one good thing I see here is that, look, we're all here to support veterans, and this is a national effort against our industry. And I will say, out of all the states that I've been to, the VFW members here in the state have been the most cordial, irrespective of our position on the issue. We understand where they're coming from. They understand where we're coming from, although we disagree on our positions. But the one thing we do agree to is that we want to do something for these veterans. Now, the VFW has told us, what some of the concerns were with some of their members being taken advantage of, and we asked them what some of those strategies were, the tactics that these bad actors were using. So they spoke, we listened, we introduced a bill, and we prohibited many of the practices that they informed us were being used to take advantage of these veterans. And you'll find that in the bill. But there is one pain point where they would like to see us accredited. And unfortunately, that would put us out of business. And that's just not something we can agree to. So up until that point, we have had great conversations. Now, those who oppose this bill largely have never used our services. They have a philosophical belief that we should not exist. And again, if that's the way they feel, that is their prerogative. I'm not here to debate their personal position. However, I do not support the idea that we are operating in violation of federal law, because irrespective of our position or our opinion on the issue, the letter of the law is what matters. And word for word, the accreditation requirement states, no individual may assist claimants in a preparation, presentation, and persecution of claims for VA benefits as an agent or attorney unless he or she has first been accredited by the VA. Now, the services we provide do not fit the definition of agent or attorney. So this bill seeks to regulate those who provide services, just stopping short of those who are agents and attorneys. Agents and attorneys represent the veteran before the VA. They represent them before the Veteran Appeals Court. We do not provide those services. We assist the veteran to prepare their paperwork so that they can self-submit the information. So it is important that this bill passes so that we can regulate a currently unregulated industry. Now, today, without this bill, we are allowed to operate. And to oppose this bill, and if this bill were to die, so could the bad actors. So if we are here to accomplish the same goal, to regulate bad actors, then we hope for a successful supported vote for House Bill 2214.
Thank you, Ray. Committee, we have no other proponent testimony. We'll open it up for questions for our proponents of the bill. Any questions? Senator Faust-Cadeau.
Thank you, Mr. Chairman. So the representative that spoke first, Rick James, You know, I used to dance to a song by Rick James.
If you need me to.
So you sounded so passionate in your presentation, and so so you're saying that you've experienced this, you support the concept of this legislation, but tell me, what is the major opposition in your opinion? Thank you, Mr. Chairman.
Well, I will tell you, thank you, Mr. Chairman. I experienced it with two separate companies that I filed for, and they both were fantastic companies. I didn't choose the VFW or any of the VSOs over the years just because of the way I felt that I wouldn't get the service that I deserved. That's the way I felt. And seeing that over 30 years as a United States Marine, I chose of. But I did choose later on a service, the VSO, not a VSO, but a veteran service group. And there's a night and day difference. I think that although there are some great VSOs out there and there's some great organizations that help and assist, it's a passion that you have to have, and you have to be able to ask all the questions, and people need to be pushed. And maybe it's the financial part for these guys to push you a little bit harder, but the whole goal is to get everything that you've earned or you think you've earned into the VA, and then that system doesn't get kicked back out, because it's a long process. If it gets kicked out of the VA back, it can take months to get it back in and get looked at.
Any other questions, committee? Oh, Senator Bowser.
Thank you, Mr. Chairman. I have a question for Colonel Taylor or Ray Cullis. This sort of debate, I think, has been around our community. And first of all, let me thank the veterans here in the room. Again, really appreciate your service. Can't thank you enough. But this debate's kind of been around our community for, I don't know, as long as I've been around, 30 plus years. But I suspect that you've probably helped more veterans than maybe have filed complaints. Do you have some numbers, some statistics on how many veterans have used your service? How many have successful outcomes? How many complaints have you had? Any numbers like that?
I don't have specific numbers on totals, but we are in the 120 to 150,000 range over the last 6 years. Our success rate is 90%. So 90% of the veterans we're working with get some type of increase in their benefits. And the best figure I can give you about satisfaction is I work with a completely voluntary payment system. I don't collect credit card information ahead of time. I don't collect bank account information. Once a veteran gets their increase, they have to take a voluntary action to pay us. My default rate is about 1.5% across 120+ thousand veterans. And we have never gone after a veteran for failure to pay. We have never filed a collection. We have never filed a credit report. That's the best figure I can give you is, and you look at our ratings, look at our Google, go on Google, Facebook, Better Business Bureau. We've won the Torch Ethics Award from the Better Business Bureau for 5 years in a row.
Any other questions, committee? Senator Clifford.
Thanks, Lieutenant Colonel. Glad you're here. I'm an Air Force Academy graduate, so we'll get along. Yes, how are we shaming or censuring the bad actors? Just BBB reports, or is there any opportunity to highlight folks who are bad actors? Thank you.
Well, and that's part of why we're here today. Because we're in an unregulated space, there's really not much that can be done unless there is real fraud going on. And there are cases where people are committing fraud, and states' attorneys general have gone after individuals for committing fraud. What we are trying to do, both at the federal level and across the states, is to put these common sense consumer protections in place. There are 8 states right now that have similar bills to this. The latest to pass was the state of Virginia, just passed out of their legislature and is on the governor's desk right now. There is an organization called the National Association of Veterans' Rights. It's our trade organization. It's led by a former VA secretary under the Trump administration, Peter O'Rourke. They are going to be working over the next several months to start working with these states that have passed bills like this to start enforcing. So if there are companies out there that are charging upfront non-refundable fees, we're going to be working with states' attorneys generals in those states to go after those actors. And that's the best way. So by passing this law, we're now giving your state not only the ability to go after these individuals, but also giving the individuals the right to come after us because of the private right of action that's included.
Thank you, Colonel Taylor.
Real quick question, real quick answer, because we need to get to the other.
Sorry, I realize that.
Very good, Senator Dietrich.
So thank you, Mr. Chair. So is it typical for the clause, or I guess we have it on page 3, line 7, number 2, civil penalties will be, could be a remedy through the Attorney General's office? Is that in other states as well?
It is as well. And
Thank
that's
you.
something that we've actually supported not only here, but in other states as well.
Okay, very good. Thank you, Colonel. Committee, we have neutral in-person testimony from Mary Lynn Poskin. Representative Poskin, is she here? I do not see her. She has provided a written testimony. It's in your packet. So we'll move on to opponent in-person testimony. We're going to skip over Colonel Turner or General Turner till the last and go to Mike Kelly first from the Military Officers Association of America. Mike, welcome.
Thank you, Mr. Chairman. Mike Kelly, I'm state president of the Military Officers Association of America, and we oppose this bill. And I want to say, very first thing I want to say is I'm going to make some strong arguments and say some strong words. I'm not vilifying anybody in this room. I respect the chairman of the House committee. I respect the proponents of this bill. I respect their service. But I have fundamental disagreements with this. As I was working up my testimony, a collaborator wrote me a statement, and this is the words of another person, but I agree 100%. This committee has a duty to protect Kansas veterans, not weaken their protections, not invite constitutional litigation, and not authorize the monetization of earned federal benefits. For these reasons, I respectfully urge you to reject HB 2214. Since the House committee heard this bill in early February, the U.S. District Court for the Middle District of Louisiana passed or issued an order that the similar Louisiana law, which is section 29296 in the Louisiana statute book, was unconstitutional. Louisiana was sued under 4 different complaints. The federal judge did not rule on 2 of those complaints, one of which had to do with the Supreme Court of Louisiana's supervision of attorneys there, and the second one had to do with a constitutional claim on the Contracts Clause. The judge did rule that the Louisiana law was unconstitutional because it limited First Amendment rights, which were some of the consumer protections that Louisiana put into law. But most fundamentally, and the one that cannot be rebutted, and is, you've heard some words that is nullified. No, the Kansas law that is being proposed here in HB 2214, and you've heard it from the proponents, they want to regulate this Veterans Claims Assistance. However you call it, consulting, assistance, medical records assembly, whatever you call it. We're going to call that Veterans Claims Assistance. And the federal government already regulates that. So that is a violation of the Supremacy Clause of the Constitution of the United States of America. State may not issue a law that contradicts federal law. And the judge, not a barracks lawyer, not me in my 30 years in the Air Force, not a judge advocate, only 3 combat deployments. The judge, who's a learned scholar, confirmed by the Senate of the United States, ruled that the bill in the law in Louisiana, which set up a regulatory scheme under the state authority was an unconstitutional violation of the Supremacy Clause. You've heard from the proponents today, they want to set up a regulatory scheme in Kansas. The Veterans Administration already regulates this. It's in federal law. It's Title 38 U.S. Code Section 5904, which is a copy of, is appended to my written testimony. And there's a Code of Federal Regulations that are passed also. Going to Kansas law. Kansas already has a consumer protection law. And that law is in Chapter 50 of the Kansas statutes. And I want to refer you to the scheme, the pricing that is proposed in this bill. And it's 5 times the monthly increase in benefits. Well, a widow whose veteran died of a service-connected disability and has the death certificate can bring that in to a VSO and apply for a survivor benefit. And it's currently $1,699 and change a month. Plus, for the first 2 years after the death of the veteran, is an additional $359 a month. So it totals up to about $2,059 a month. Multiply that times 5, that's $10,290 some dollars for something that a VSO can file that for free at no charge to the claimant. So to me, and I'm not an attorney, but to me, that's grossly excessive pricing, and that's 50-627B2 prohibits grossly excessive pricing in consumer transactions in Kansas. Kansas already has an accredited system. You see lots of folks here from the VFW and my organization and the Kansas Office of Veteran Services. They can do this job at no cost to the claimant. You've heard the proponents say, oh, what we do is legal. Well, the Veterans Administration Office of General Counsel disagrees. And they've sent out letters of warning and notices of the law. And I have one here for a company that's not one of the ones that testified today. But some journalists did a Freedom of Information Act request and said, we'd like all the warning letters sent to these veterans claims assistance companies. They got over 40 of these back. And the 2 proponents that spoke today, both have received such letters. They're appended to my written testimony. And they have the OGC FOIA at the bottom. That's a VA Office of General Counsel Freedom of Information Act case. So these are official records of the federal government. These companies are on notice. What they're doing is a violation of law. It's going to be adjudicated. It's going to come to a head somewhere, sometime, but there's going to be litigation to resolve these separate claims. But right now, the federal government says these guys are out of bounds. Okay, stroke and distance if you're playing golf. This bill permits these out-of-state companies to charge fees to Kansas veterans and veteran survivors, and that money goes to the economies of North Carolina and Nevada for the 2 proponents that testified today. That's money that should stay in Kansas. One of the companies that testified today, their representative testified today, they have a number of court cases in the Middle District of North Carolina. One of them is a class action lawsuit that was certified over the objections of the company. And those claims, which have not been adjudicated yet, but have been left to go to trial, are for violations of the North Carolina Unfair and Deceptive Trade Practices Act and the North Carolina Debt Collection Act. In the note that goes out, postcard note that goes out to all of the folks in the class, it was noted that $250 million is the revenue of that company over 6 years, $250 million. And that complaint is in my written exhibit in my written testimony. Furthermore, same North Carolina company has got another case against it. And once again, these allegations have not been proven, presumption of innocence. However, the U.S. Attorney, through a former employee's firsthand observation, claims the proponent consulted on claims documentation that was forwarded to the VA for a decision in a conspiracy to inflate mental health disabilities of veterans claimants. And that 60-page complaint is appended to my written testimony. In summation, precious Kansas taxpayer dollars should be expended on activities that advance the public good, not thrown needlessly away on unpromising efforts to defend laws like HB 2214 that decrease the consumer protection of veterans, as I've explained. They remove income from Kansas consumers and, as a judge ruled in Louisiana, illegally subvert the Constitution of the United States of America. Stand for questions at the right time, sir. Thank you.
Thank you, Mike. And committee, we run till 1 o'clock, so we're really, future conferees coming up. I want to give the committee time to ask some questions, so try to keep it as brief as you can. David Kennedy from VFW is up next. David?
David Kennedy of BSO. I've been 33 years military, 11 years as a BSO. I work out at Robert J. Dole. Am I close enough? At the VA hospital in Wichita, I have an office there. Mike Kelly asked me to talk about DIC, which is survivor benefits, claims, and fully developed claims. If everything is correct in a service-connected claim for death, they have the death certificate. He's in the VA. It's service-related, cause of death. It's on the death certificate. Everything is perfect. Then the claim is going to be approved in a short time. The problem is that's only about 10% of our claims. Most of our claims are not fully developed claims. It takes work. It takes medical records. The veteran is not getting VA treatment. We need to go get those medical records. We bring them in. We may end up in appeal. So, and this is not just death benefits. This is all claims. So if everybody was in the VA system, it'd be great, but they're not. So that's where we come in. So also, the biggest reasons for being turned down in a VA claim, VSOs don't make those decisions. VA, we file the claims, the VA makes the decisions. VA decides no current diagnosis or there's not in your service treatment records. Two biggest reasons why you're turned down. Okay, that's not the VSO not doing their job. That's you don't deserve that because it never happened, is what the VA says in their wording. Okay, so I'll try to make it quick now. You've heard the CFR 3814.629. You've heard it quoted to you twice. I think they're misrepresentative. It's pretty clear. No individual will file claims unless they've first been accredited, period. Okay, there's no change in wording here. That's what the VA says. That's their regulation. Okay, for me to be accredited, I've got to, first of all, we got to, state of Kansas has to agree to hire me. And then we're going to do a local background check on you to make sure we're not embarrassed. Then they turn that over to National VFW. They look at us and look at our application. Then they turn that over to the Office of General Counsel at the VA. They look us over, and then they agree to hire us, and then they're going to do a federal background check on us. Then we got to live by all the privacy and security rules by all VA employees have to go by, which means we can be trusted with the veterans' information. Okay? And then we're going to look in our, if you don't have access to VBMS in the VA, how are you going to file claims? You're going to be totally blind. You're going to be shooting in the dark, filing claims. Also, they say that they can get faster, better results. That's nonsense. It's not going to happen. VA takes claims as they come in, And there is no priority except unless they're financial or they're terminally ill. That's the only two decisions that they'll make it faster. But other than that, you file a claim and you take a number behind the last veteran. Okay? So why accredited? All professions are regulated by somebody. Whether you're a real estate agent, my wife is a real estate agent, you know, she has to meet training and requirements every year. Plumbers have to be required, and I know somebody's running for insurance commissioner. If you're unlicensed to sell insurance, and I would hate to be that person if you found out about it, because you'd be out of business pretty quick. So I heard 3 state representatives tell you how they had good services through these VSOs, and I would like to say that, you know, these were probably retired veterans who, you know, may have had a good, you know, but they could afford the money that they paid was not a big deal, and also they put themselves at risk by giving unaccredited people information to out-of-state, and they have no idea what they're going to do with their information. Then they pass a House bill that's going to put other veterans in the same risk. And just because these two may be good characters in this room, doesn't mean we got a whole list in the VFW that covers a full page of bad actors. So I think I said it all.
Okay, thank you very much. Unfortunately, I've got Donnie Collier, Jim Carlin, I never can pronounce Jim's name, Carlins, and General Turner left to testify, but I'm running out of time. I would like to open it up for questions from the committee to any of the opponents, and all your written testimony is in our on the internal drive for everyone, and we can ask questions of those who are here. So committee, any questions? We'll run it right up to 1 o'clock. Senator Fausto.
Thank you, Mr. Chairman. And Mr. Chairman, just for clarification, he's always doing the silent part. Well, I'll ask Ray, and I'll ask, yes, both of you. I don't know if I can ask both, but just the same question. So, you know, I live in Wichita. And I was appointed by Senator Jerry Moran to serve on a Veterans Advisory Board. And so I kind of know a lot of people that go to the Dole Institute there on Kellogg in Wichita, and it's so many of them, wow. So don't you think that this legislation would help that offset? And I thought they were just providing a service to help an individual process the application, not file the claim, but just to fill out the application. So wouldn't you want the help? Thank you.
The help is available from David Kennedy. It's also available from the KOVS at no cost to the claimant. And that's where the rub is, one of the rubs in this. These folks will charge up to 5 times the monthly increase in benefits. If a person goes from no finding to 100%, that's almost $20,000. And they can talk to David Kennedy, and he's told me he takes walk-ins, and I'm sure he'll come up and testify to that again, that people in Wichita can come and see him. So there are people at the KOVS. And the KOVS will, if you can't get a local person to see you, they can get you in a video conference with one of their representatives that has got an appointment available. So there's help available at no cost to the claimants. Thank you, ma'am.
I'll ask General Turner if he, go ahead.
So the gentleman who just spoke is right. There is an alternative service. This, again, is only an option. But I do want to make clear that 70% of the veterans who have tried our services have also tried the free service to the lack of success. And when we say free, the Department of Veteran Affairs just came out with the 12-month numbers. for the fees that were charged by attorneys and agents. Now, the current system incentivizes the correction of failure. That's what appeals are. The numbers were $32 million a month. So it came in at over a 12-month period of just under $400 million a month. That is a far cry from zero.
Very good. For General Turner, I know we didn't have a chance to let you speak. If you just want to weigh in here a little bit for the committee before we.
Yes, sir. Thank you very much, sir. And thank you for the opportunity to speak for a moment. This issue is as complex as it is to try to go through the process of initiating a claim and doing this. This is just symbolic, indicative of what our veterans are going through. So the issues that you are weighing here today, I think is really illustrative of what they go through in terms of the complexities, drawing on buddy statements, drawing on medical records, drawing on past history. About 47% of our veterans in the state are Vietnam veterans, dating back, a number of years, trying to recollect and to file their claims and do this process. Our nation made a commitment to our veterans with the establishment of the Veterans Administration. And as such, I believe it's our moral obligation to provide those services to our veterans and their families and those that support them in our communities. And this is something that's been established years and years and years ago that grew during the Civil War time and has continued to grow and the VA has come in leaps and bounds to help folks. So these services, as I said, we have trained, accredited folks that are out there that have been vetted that provide these services. I cannot, in my good conscience, our mission in the Kansas Office of Veteran Services is to inform, advise, assist, and advocate for our veterans. I cannot, in good conscience, I cannot endorse or to advocate for a practice whereby we are charging veterans large sums of money, exorbitant fees, quite frankly, for limited time of work to help do the work that we are already doing to help put together these stories, tell the narrative of that veteran. Like they said, you've already heard from people that it's not done any faster at the VA, it's not prioritized any differently. I just had a chance to be at a conference in DC, we just came back last night from, where we heard Secretary Collins and members of the Veterans Benefits Administration and the Health Administration. The average claims have come down now in the adjudications from 132 days to 77 days is the average by which these claims are going through the process. So we have great success rates. You'll hear anecdotal stories of success on both sides. You'll hear frustrations and challenges. But our mission is to help to take that veteran in, listen to their story, get their information, put it together, and submit that. And so partnered with our VSOs, as you heard from Mr. Kennedy, we're very proud. It's an honor and a privilege, and we take great pride in what we do. We're not motivated by the money. We're motivated by the service that we're able to give back to our veterans. They have already paid for this service by what they've done to defend our Constitution and serve our nation. So thank you very much, sir.
Thank you, General. Committee, it's kind of a tight spot here. I know a lot have 130 committees. I know I do. And we've got, I'm sure many of the conferees would hang around if you have specific questions for them. The lunch for staff and committee has arrived. And this is a very complex situation. So I would suggest you reach out to any of the conferees you have questions for. So next week, what we will do is we'll hear House Bill 2627, which is the final bill on the list, and we will consider working the two bills we just heard. But again, I urge you to talk to any of the conferees to any questions that you need to ask, and that way you can get some lunch and get to your 1:30 meetings on time. Apologize to anybody who didn't get to testify today. Unfortunately, we just have a very short time frame, and we thank you for committee and staff for all your work.